My name is Martha Ackelsberg. I'm in the Gov Department and Study of Women and Gender, and Carrie Baker in the Study of Women and Gender, and we are here, as I hope you all are, to talk about social injustice and the Supreme Court, and to think about the three big cases that were decided this summer at the end of June. I just want to tell you a little bit about our plan for the workshop, and then we will get into it. I'm going to provide some framing for the conversation, a little bit on the history, very schematic and brief history of the civil rights movement and its legacies. Then we'll review the three decisions that we'll be discussing on voting rights, same-sex marriage, and affirmative action. So you'll know a bit about what was at stake, what was decided, and what has happened since those decisions at the end of June. Then we'll take questions, and then we have some brief passages from the decisions that we'll look at both in small groups and then in a larger group, so we can see what some of the questions that were at stake, how they developed, and the implications we might draw from them moving forward. Okay, so that's our general plan. So let me just say a little bit for those of you who may not know it or who may not have this particular take anyway on the history of the civil rights movement in the United States. As Carrie and I were discussing the cases and this workshop, we came to believe that all three of the cases can be seen to have grown out of the civil rights movement in the United States, particularly as it manifested itself in the 1950s and 60s. That may seem more obvious in some cases than in others, but I want to give a very brief and schematic overview of that history and what we see as some of its lessons, so that you can understand where we're coming from and how we understand the current cases and the debates around them. So first of all, against the background of slavery and then of Jim Crow, which for those of you, there may be somebody who doesn't know what that term refers to, but laws that either required or enabled disparate discriminatory treatment for African Americans, particularly in the South. Against that background, there developed a substantial movement activism and cases that went to the Supreme Court, demanding, as Martin Luther King said in his I Have a Dream speech of August 1963, that the U.S. make good on its promissory note. Instead of honoring this sacred obligation, he said, America has given the Negro people a bad check. We have come to cash this check, a check that will give us, upon demand, the riches of freedom and the security of justice. The march in 1963, and we just celebrated the 50th anniversary of that march this summer, and the movement which had given rise to it and which continued to flow from it, was demanding truly equal treatment for blacks and whites and everyone else, and full citizenship rights to all of those to whom those rights had been denied. The civil rights movement in the courts is usually dated from 1954, the Brown versus Board of Education of Topeka decision that ordered an end to racially segregated schools. But in fact, the movement for equality had started long before. In any case, in that case, and in a raft of others which followed, the movement against legally sanctioned discrimination, in other words, discrimination that was required and enabled by law, separate school systems, segregation on public transportation, at lunch counters, in public accommodations, and in marriage, which was cited, and discrimination against marriage in the Loving versus Virginia case was decided in 1967, and that was in fact one of the cases that was cited as a precedent for the overturning of DOMA this summer. So there were all of these laws on the books, mostly in the South, but in some other places, that required segregation. The civil rights movement and these cases of the 1950s and 60s addressed other practices that tolerated or promoted injustice and unequal treatment as well. Poll taxes, intimidation, and other barriers to voting. Oops, I lost one of my pages here. Oh, sorry, never mind. And employment discrimination was another focus of these cases. And of course, as many historians and critics have noted, the Black civil rights movement gave rise to many others. La Raza, women's rights, gay rights, all demanding that the United States live up to its stated commitments to treating everyone equally. The vote here was important on two levels, and I want to emphasize that because we're going to be coming back to the Voting Rights Act as one of those cases that was decided this summer. First, because it is a right of citizenship, a basic right of citizenship, that was being denied to Black people in many states of the Old South. And second, because the vote was seen as an important tool that people who had been previously excluded from full citizenship could use within the political process to make claims for rights that they had been denied, and to be sure that they would not be neglected or denied again in the future. That movement, as I've already to some extent hinted, gave rise to at least three major streams of activism, court cases, and policies to try to address or redress what were recognized at the time as structural inequalities. Inequalities that were required by law and that were built into the institutions and practices of the United States that effectively deprived people of equal rights under the law. Each of the streams of cases and activism and policy that came out of these were seen as temporary measures to address what were then recognized to be unconstitutional, legally sanctioned social, economic, and cultural barriers to equal rights. So one major stream of cases was, of course, the school desegregation cases. Brown versus Board of Education in 1954, what became known as Brown 2 a year or two later, Keyes, and a whole stream of others that found unconstitutional what are called dual school systems that were segregated, separate schools for Black children and white children that had existed in the South and elsewhere. The court ruled first that separate but equal is inherently unequal. That's probably the line from that case that people are most familiar with. And ultimately that districts that had dual systems had to act with all deliberate speed to dismantle them and create unitary systems, that is to say, one school system for all children, where there had been clear governmental action to create separate school systems. The court said there had to be affirmative governmental action to create a single unitary system, to reverse the discriminatory actions. In the following years and by the mid-1970s, however, the country found itself in a new situation. Southern schools were often more integrated than those in the North, and Northern schools were becoming increasingly segregated because of residential segregation. The Supreme Court increasingly ruled that if schools ended up segregated in effect, de facto in legal language, but not as a result of explicit policies, de jure, that did not create a constitutional violation. In fact, in a very important case, parents involved in community schools, that was decided in 2007, and which was cited again in the voting rights case this summer, the court ruled that communities could not use race as a factor in placing children in schools, even if the purpose was to help maintain integrated classrooms. Okay, so that's one strand of cases and policies. A second had to do with the Civil Rights Act of 1964, which prohibited discrimination on the basis of race, color, religion, sex, or national origin. This effectively outlawed all of the Jim Crow laws that had been in existence and had been found initially constitutional in Plessy versus Ferguson in 1896. And it was meant to address discrimination in all arenas: transportation, public accommodation, and very importantly, employment. And then a third stream was what resulted in the Voting Rights Act of 1965, which had a number of provisions outlawing practices which resulted in exceedingly low voter registration and the use of tests and devices to keep blacks from registering, and low voting rates among black Americans. This was pegged to voting rates in the 1964 presidential election. And it required states and counties with low rates to pre-clear with the federal government any changes to voter registration practices so that they couldn't be reimposing barriers to African Americans in voting. A number of states and counties with low registration or low turnout rates were placed under these monitoring provisions, and in later years, as the act was reauthorized, more and more local areas were included under its provisions, including certain counties in New York, California, Alaska, Arizona, Texas, Florida, New Hampshire, and South Dakota, as well as the states of the so-called Old South. And the tests and devices were expanded to include English-only instructions where there are large non-English speaking populations. Again, let me just emphasize that each of these sets of policies were attempted to stop or reverse structural, legally enforced inequalities that deprived people of individual rights. In effect, these laws were saying existing practices do not allow people of color, especially African Americans, to be treated as equal rights-bearing individuals. Instead, they are treated differently because of membership in a group, and we need to start treating them simply as individuals, just like anybody else. Final piece I want to mention here is affirmative action. In June 1965, shortly before he signed the historic Voting Rights Act, Lyndon Johnson made a very important speech, which was actually a commencement address, I think, at Howard University, in which he argued that formal freedom and equality were not enough. I want to quote from it in a little bit at length because it's not necessarily very well known, but I think it's tremendously important. "Freedom is not enough," he wrote. "You do not wipe away the scars of centuries by saying, 'Now you are free to go where you want and do as you desire.' You do not take a person who for years has been hobbled by chains and liberate him, bring him up to the starting line of a race, and then say, 'You are free to compete with all the others,' and still justly believe that you have been completely fair. It's not enough just to open the gates of opportunity. All of our citizens must have the ability to walk through those gates. We seek not just equality as a right and a theory, but equality as a fact and equality as a result. Equal opportunity is essential, but not enough. Ability is not just the product of birth. Ability is stretched or stunted by the family that you live with and the neighborhood you live in, by the school you go to and the poverty or the richness of your surroundings." Johnson realized and insisted in this speech that structural barriers continued to exist even though laws requiring discrimination had been eliminated. Equal opportunity would not be real unless and until those structural barriers fell. And in the meantime, there needed to be programs that would acknowledge the inequalities and try to compensate for them. And so in 1965, he issued Executive Order 11246, which required government employers to take affirmative action to hire without regard to race, religion, and national origin, and to assure that all employees were treated fairly. Nevertheless, and this is what we want to leave you with respect to this brief overview, many of the policies that flowed from these acts continued to use individualist language and individual-focused strategies to address what at least some people, including the President of the United States, recognized to be structural problems. And they've given rise to more contemporary claims that we are in a post-racial society, as Dr. Malveaux mentioned, where we need to be colorblind, and that word appeared in a number of the Supreme Court cases this summer, and not take into account differences in opportunities, educational background, et cetera, that might account for differences in outcomes. All right, so what were the decisions of this past June? I'll just do this and then we won't be going back and forth the whole time. Okay, so one of them was Shelby v. Holder that was decided on June 25th. This was a review of a number of sections of the Voting Rights Act of 1965 that had been amended and reauthorized many times since with overwhelming majorities. In 2006, for example, which was the last time that the Voting Rights Act was reauthorized, the Senate voted 98-0 in favor of reauthorizing this bill, and the House of Representatives supported its extension by a vote of 390-33. So we're talking major support in Congress, the likes of which we haven't seen on many issues, certainly in recent days. Section 2 of that act bans any standard practice or procedure that results in a denial or abridgment of the right of any citizen to vote on account of race or color. That section was not at issue in the case this summer. Section 4, however, provided what was called a coverage formula that listed certain states and jurisdictions where there was evidence of actual voting discrimination based on standards that were used in the original 1965 Act. And Section 5 said that if those jurisdictions wanted to change their voter registration or anything else having to do with voting regulations, they would have to seek pre-clearance from the federal government to be sure that they would not infringe on minority rights. It was Sections 4 and particularly Section 5 that was challenged in the case this summer. The court found Section 4 unconstitutional on the grounds that the basis for the coverage formula was old and out of date, based on decades-old data and eradicated practices, in the language of the decision, that in effect it discriminates against those jurisdictions by subjecting them to federal oversight that is humiliating and no longer necessary. It acknowledged that voter discrimination still exists. They said, in fact, no one doubts that, but they said we don't need basically such a heavy set of rules and regulations in order to protect against it. Furthermore, it said that Section 2 still exists, which said that if you think that that any changes are going to, or that laws are having a discriminatory effect, you can challenge them in the courts, and they can be stopped. The Voting Rights Act, the court insisted, represented an extraordinary intervention in states' rights and was justified only by the blight of racial discrimination in voting that, quote, had infected the electoral process in parts of our country for nearly a century, unquote. Since that sort of blatant racial discrimination no longer exists, it argued, indeed, voter registration and turnout in many of these states and jurisdictions is above the national average, the extraordinary measure of requiring pre-clearance from the federal government is no longer necessary. The country has changed, in other words. Blatant discrimination no longer exists, even if it were the case, which the court acknowledged, that things changed because of the Voting Rights Act. That is no justification for leaving in place violations of states' rights that are based in long ago behavior. Ruth Bader Ginsburg wrote a very powerful dissent in this case, arguing that Congress did not simply continue the old formula without noticing that things had changed. In fact, Congress had engaged in extensive research and review and found that systematic and intentional discrimination remains pervasive in these covered districts. The fact that so many requests by these jurisdictions for changing rules had been rejected by the Department of Justice, she argued, was evidence that the problem in fact did still exist. Ginsburg's dissent noted that Department of Justice objections blocked over 700 proposed changes to voting laws between 1982 and 2006. So it's not like we're talking about old stories and old history. The issue now, she insisted, is as much racial gerrymandering, attempts at voter dilution, voter identification laws, all this kind of stuff, rather than simply trying to prevent people from voting in a very overt way. And those practices need to be monitored from the get-go. Using Section 2 is too slow, it's too costly to petitioners, and more to the point, it can only be used after the fact. So you could say, you'd have to wait until all kinds of people have been denied the right to vote and then go to court and say, we've been denied the right to vote, and meantime, the other guys have, won the election. In other words, the structural state-based problems still exist, and they need structural rather than individually based solutions. Now, finally, let me just say a little bit about what's happened since the decision, and then Carrie's going to talk about the other two cases. Since June, Texas unveiled a redistricting plan and enacted a law that requires voters to present identification before casting a ballot. North Carolina passed the nation's most restrictive voting law in August. The law contains dozens of measures that will discourage voting. The most draconian included requiring a photo ID to vote, banning counties from extending voting hours due to extraordinary events, eliminating pre-registration for 16 and 17-year-olds, eliminating the state's same-day voter registration program, no longer allowing provisional voting if someone goes to the wrong precinct, shortening the early voting period, doing away with the same-day registration program, and instituting a photo identification requirement. These have nothing to do with trying to cut back on voting, right? Alabama, Mississippi, Virginia, Arizona, and South Carolina, among others, all states that were required to seek pre-clearance before changing their laws under Section 5, all passed laws requiring photo identification in order to vote. The federal government has responded almost immediately. The Justice Department joined a lawsuit against the Texas redistricting plan and is filing a lawsuit challenging the voter identification law. The Justice Department also challenged several provisions of North Carolina's law in a suit filed in late September. It alleges that North Carolina's law, cutbacks to early voting, elimination of same-day registration, etc., violates Section 2 of the Voting Rights Act. And the department also argues that these voting changes were enacted with intentional discrimination, and thus North Carolina should have to approve all of its voting changes with the federal government for a period of time. So that's where things stand with voting rights decision and the Voting Rights Act.
Okay, there were two other significant decisions that we want to talk about today, and one is Fisher versus University of Texas at Austin, which was a United States Supreme Court case concerning affirmative action admissions policy at the University of Texas at Austin. So I want to talk a little bit about the facts of the case and how the court ruled in the case and what's happened subsequently. The plaintiff was, there were actually two plaintiffs initially, and the second one dropped out, but they were Abigail Noel Fisher and Rachel Moulter Michaelwitz, and so Fisher stayed in the case all the way through. They applied to University of Texas at Austin in 2008, and they were denied admission. Both women were white. They filed suit alleging that the university had discriminated against them on the basis of race in violation of the Equal Protection Clause of the 14th Amendment. So the University of Texas at Austin accepts students in the top 10% of each Texas high school's graduating class, regardless of their race. And these kinds of policies have been put in place because of racial segregation in schools. Despite Brown versus Board of Education, we know that, as Martha mentioned, residential segregation has led to extremely polarized schools. And so Texas's attempt to try to address that was to take the top 10% of every school in Texas. And that constituted 81% of the 2008's freshman class that were admitted. Applicants who, like like Fisher, failed to graduate in the top 10% of their high schools have a further opportunity to gain admission to the university by scoring highly in a process which evaluates their talents, leadership qualities, family circumstances, and race. So race is one of many factors that, in addition to grades and SAT scores, that the university looks at in order to make admissions. So Fisher had a grade point average of 3.9 on a 4.0 scale and was in the top 12% of her class. She scored 1180 on the SATs, and that was when it was still on a 1,600 point scale. And so she was around the 30th percentile at UT Austin as far as her scores. And she was involved, she had extracurriculars, orchestra, a math competition, and she volunteered at Habitat for Humanity. She filed this case initially in the district court, and the court upheld the legality of the university's admission policy in a summary judgment motion. So they said this complies with the previous decisions that the court has handed down to set the standard for affirmative action. And the case was appealed to the Fifth Circuit, and the Fifth Circuit also ruled in the university's favor. And then the plaintiffs appealed to the United States Supreme Court. So Fisher asked the court to declare that the university's race-conscious admissions were inconsistent with the prevailing Supreme Court precedent on affirmative action set out in Grutter versus Bollinger, which had in 2003 established that race had an appropriate but limited role in the admissions policies of public universities. The Supreme Court held that the lower court had not applied the standard of strict scrutiny articulated in Grutter versus Bollinger, and also another case, Regents of University of California versus Bakke, to the university's admission program. So the Supreme Court's ruling in Fisher took Grutter and Bakke as given and didn't directly revisit the constitutionality of using race as a factor in admissions. What they said was the lower court just hadn't been strict enough and questioned the use of race closely enough. And then they remanded the case back down to the lower court. So they weren't addressing the constitutionality of affirmative action. They were looking at how the lower court had applied the test of strict scrutiny. And what that test is if a law or policy classifies based on race, the government has to prove that that classification is necessary to achieve a compelling government interest. And what Texas was alleging in the case was that their compelling government interest is having a diverse student body that reflects the population of Texas. And what the court questioned was whether, the Supreme Court questioned whether the lower court had adequately looked at whether the way that University of Texas used race as a factor was narrowly tailored to achieve that goal of diverse educational environment. I want to say a little bit about Grutter versus Bollinger. It was a 2003 case, a landmark case in which the United States upheld affirmative action admission policies at University of Michigan Law School. It was written by Sandra Day O'Connor. And what she ruled was that Michigan Law School had a compelling interest in promoting class diversity. So that was the case which accepted diversity as a compelling government interest. The court held that a race-conscious admissions process that may favor underrepresented minority groups, but that also took into account many other factors evaluated on an individual basis for every applicant, did not amount to a quota system that would have been unconstitutional under the Bakke decision. Okay, so Bakke said no quotas, but you can still have affirmative action. So after Bakke, the Supreme Court recently agreed to review another case out of Texas, and this was argued just a couple months ago, which also involved the University of Michigan. The day after the Grutter decision in 2003, where the Supreme Court upheld the University of Michigan Law School's affirmative action policy, opponents of affirmative action launched a referendum campaign to bar such programs, and in 2006, voters approved a ballot initiative amending the state constitution to ban affirmative action programs in higher education. And that amendment was passed 58% in favor. So Michigan state colleges and universities promptly abandoned any use of race or ethnicity to promote diversity, and minority enrollment dropped in the university systems. In 2012, a federal appeals court ruled that the referendum itself was discriminatory because it, quote, reorders the political process in Michigan to place special burdens on minority interests. This decision was upheld by the full Court of Appeals, and the Michigan Attorney General appealed the ruling to the Supreme Court. And that's what's currently before the court. And the case is called Chouette versus Coalition to Defend Affirmative Action. And so just briefly, the argument in that case was that the amendment to the Constitution violates the political restructuring doctrine, which is a doctrine that the court has adopted that says that government may not enact any changes to the political process that will make it harder for minorities to exercise their rights. Okay, so that decision is currently pending before the court, and it was argued just a couple months ago, and we'll hear more about that. All right, so then we had the U.S. versus Windsor, which is the DOMA case, the Defense of Marriage case. So in that case, the Supreme Court struck down Section 3 of the Defense of Marriage Act, which defined marriage as the legal union of one man and one woman for federal purposes in the United States. Another section of the act stated that no U.S. state or political subdivision is required to recognize a same-sex marriage from another state. And that section was not at issue, so that section is still in force. So this only had to do with how the federal government defines marriage. So let me go back and give a little bit of the backstory. Hawaii Supreme Court, back in the early 90s, ruled that the provision that prohibited same-sex couples from getting married in Hawaii statutory law violated the Hawaii Equal Protection Clause of their own constitution. In response to that, the Congress passed the Defense of Marriage Act, and then many other states also passed Defense of Marriage Act. The irony of this is that Hawaii then went on to amend their constitution and rule that you could have civil unions but not marriage, although currently that's being revisited in Hawaii. So Bill Clinton signed the Defense of Marriage Act, and again it said that same-sex couples couldn't get married. And that was passed by an overwhelming majority of the Congress, and the language used to justify that act was clearly very discriminatory and invidious. If you look at the congressional record, the intent was clearly to disadvantage this group, this minority group. So the facts of U.S. versus Windsor. So Edie Windsor, she was married to Thea Spire. They lived in New York City. They'd gotten married in Canada and then moved to New York. They were lawfully married. As I said, Spire died in 2009, leaving her entire estate to Edie Windsor. Windsor sought to claim that the federal tax exemption for surviving spouses should apply to her. But because of DOMA and because marriage was defined as between one woman and one man, she couldn't get that federal tax exemption. And so she had to pay $363,000 to the federal government. And that was the provision that she challenged. And the court in that case ruled under the Due Process Clause of the Fifth Amendment that the defining marriage as just the marriage between a man and a woman violated the Constitution. And Kennedy wrote the decision, and he struck it down on principles of state autonomy. The federal government was not recognizing state marriage laws, okay, and equal protection as well as liberty. So it had concepts of federalism, allowing the states to determine what marriage is for themselves rather than the federal government denying that definition, but also equal protection and due process. By the way, on the same day, there was another ruling on same-sex marriage. It was the California case, Hollingsworth versus Perry. And in that case, basically the court said that the people challenging the California ruling didn't have standing. So they didn't rule on the merits of same-sex marriage, but they did allow same-sex marriage to go forward in California. So those were the three cases. Martha, do you want to?
Yeah, so we thought we could leave a few minutes now. Do you want to say a little bit about what has happened since?
Okay. Yeah, so just a little bit about what's happened with the DOMA case. Shortly after the decision, a number of federal agencies declared that they were going to now recognize same-sex marriage, like U.S. Citizenship and Immigration Services, ICE, said that it would recognize, it would implement the Supreme Court ruling by recognizing same-sex marriages for immigration purposes. The Office of Personnel and Management announced that it would be able to extend benefits to federal employees who were in same-sex marriages. The Department of State, John Kerry, issued a statement saying that same-sex spouses also applying for a visa would be able to get one. The IRS announced that they would recognize it, veterans benefits also, and Social Security benefits. So a number of federal agencies quickly ruled that they would acknowledge same-sex marriages.
Great. All right, so that's our very brief overview of the cases. We wanted to leave a little time just if people had any questions about anything that we've said so far. Okay. All right, then we'll just move right along. So, oh, I'm sorry. Yeah.
Wasn't there another case that challenged tribal sovereignty and the rights of tribal nations to determine what family means? Wasn't there another?
The Baby Veronica case? Yes.
There have been lots of other cases, but we're just focusing on these three. Yeah, we're not. This is not a con law review session, unfortunately. Okay, all right. So we picked out a few passages from each of these cases to give you a sense of the language in the decisions and in the dissents. So on the top, this is the Shelby case, the voting rights case, which was written by Chief Justice Roberts. And on the bottom, a piece from Justice Ginsburg's quite impassioned dissent. And we thought that what we would do is ask you to talk with people around you for a few minutes. Read these, read them, think about them, talk about them, and discuss a little bit how the passage or the author frames the issues that it's addressing here, and what you find compelling about that framing, and what you find problematic about it. And then we'll come back and take comments, questions, and see what anyone has to say about it, okay? So take a few minutes and talk to the people nearby. And you might begin by introducing yourselves.
Not a very chatty crowd, but I think this will generate more discussion.
Sure.
You know, I didn't get a whole lot into the reasoning of the cases. I feel like you got more into the reasoning, and maybe I should have, but
I think it's fine. I mean, if they wanted more, they would have asked, which they didn't. So.
right.
I might have done too much. So.
No, I thought it was good. We definitely need to come back to your points about individual versus structural.
It's really, of course, as you said, that it wasn't Roberts who wrote the DOMA decision. It was Kenan.
Yes, it was Kenan.
As you said, but so that also accounts. Roberts was in dissent.
He was in dissent. Okay, I had misstated that yesterday, right?
Yeah.
In your office, yeah. Roberts wrote the Shelby decision, not the, right, which makes sense.
Which is fine, but it makes it more understandable how the other one got decided.
Right. But Kennedy was in the majority in Shelby.
Right, almost everybody.
Except Ginsburg.
Except, yeah.
And who else?
I think even Sotomayor was.
In the Voting Rights Act case? Wait, I have it right here.
Maybe not. That doesn't make sense.
Yeah.
She was in the majority in
Okay, the Roberts delivered the opinion of the court with Scalia, Kennedy, Thomas, and Alito joined.
Oh, okay.
Thomas filed a concurring opinion. Ginsburg filed a dissenting opinion. Breyer, Sotomayor, and Kenan joined.
Okay.
So Kennedy was the swing vote.
Yeah.
And it kind of surprises me in one sense, but I don't know enough about Kennedy to know why he would be in the majority on that. But it's interesting that he was in the majority in DOMA, but also in Shelby.
Yeah.
So he would be our person who has this very traditional idea of rights, and will go along with marriage rights, but not with voting rights.
Right.
Yeah. So. It'll be interesting to hear how people think these two framed it. I thought the Baby Veronica case, was it decided or has it just been argued? I thought it had just been argued and not decided. I'm pretty sure that's the case.
Yeah, I don't know.
But maybe it has been decided already. It was a Cherokee man and a non-Cherokee woman she got pregnant and she gave birth and adopted out the baby.
Oh, right.
Knowing.
Yeah, right.
But they're tribal rights. You can't just raise, and so whereas men normally don't have rights unless they establish them. In this case, because he was a member of the tribe.
Right. So maybe it has been decided because I think there were, I've seen pictures of because the child's now about 3 or something, right?
Yeah.
Right. So she was being returned, but the parents were. Right. The adopted parents were. Right.
How long do you think we should give them? When did we start? Like 10 after 3?
Probably about 10 after.
So we shouldn't go past 4:30.
Oh no, I don't. I think we may.
This day is
just
gone
about
long.
15 minutes. Yeah. We'll see how.
Do you think we should come back?
Yeah, probably.
Do you want me to?
Do you want to take this one and I'll? However.
Yeah. Oh, they are chatting though. They clearly have a lot to say.
Some of them.
Maybe they're talking about the weather.
I think we could reconvene.
All right, can we reconvene? So, what do folks think? How do these two passages? So again, there's one from the majority decision and one from the dissent. How do these two differ in the way they frame the issue?
Yeah.
Well, there's a lot more concrete sort of evidence. Well, not necessarily, maybe evidence isn't the best word to use, but the first one sort of making more just like broad statements, and the second one is more specific, using words like voter ID laws, gerrymandering, first generation.
Okay, someone else? Yeah.
Oh.
Well, I have a question that reading this made me think of, because I know that when you provided some additional context and details, she, Ruth Bader Ginsburg had 700 or, she had a lot of hard, concrete evidence that said this is the data that is supporting that this still needs to be in effect. And when we read the opinion of the court, it doesn't really provide that hard data, and it seems to me that if they were going to write the opinion report, what data did they use? Did they not use any? Did they see the 700?
Well, they were very aware of the record, and Congress, in passing the revision of the Voting Rights Act, had hours and hours of hearing, created a huge record, and Ginsburg references that in her dissent. And so they were very aware of it, but they chose to ignore it.
Well, but they did have data. You have to remember, we just chose these two passages. They are in some ways reflective of the tone of the decision, but the decisions are dozens of, I mean, the main decision is dozens of pages, so it's not all there. They did have, we were talking about whether to provide you with this, but it seemed, you know, a little de trop. But they did have data here showing the black-white gap in turnout in 1965 in 7 states, and then the black-white gap in turnout in 2004. And what they argued was there's no gap, there's basically no gap left in turnout, and in fact, in many of these places, the black voting turnout, black voting rate is just as high, if not higher, than the white rate, so therefore we don't need any laws. So
Did they discuss who would be affected by voter ID laws, or did they just say like, oh, you know, black, white, we're equal, okay, whatever?
they didn't, you know, basically they said, if these laws are going to have discriminatory effect, people can challenge them under Section 2. It's basically what they said, and Ginsburg said, you know, Section 2 is too late. It's after the fact.
So of those 700, 600 of them were prevented from going into effect because of the pre-clearance provision. 100 of them were lawsuits brought either by the Department of Justice or by individual plaintiffs against provisions. And that's a much more burdensome process, and the law actually goes into effect and then you challenge it, so you could lose, you know, a lot in the meantime. So the majority focused on numbers, focused on voter registration, voter turnout, and representation. And they said, back then it was really bad, now it's about equal, there's no longer any problem. But Ginsburg made an interesting comment, this is my favorite line out of the dissent. Throwing out preclearance when it has worked is continuing to work, Throwing out preclearance when it has worked is continuing to work to stop discriminatory changes. It's like throwing away your umbrella in a rainstorm because you're not getting wet. And so, I mean, the argument is that it was because of all these preclearance suits that the numbers became equal. And that these other methods that she mentions here are ways of diluting the black vote.
Yeah.
We also see in the second passage a far more nuanced understanding of what it means to, you know, when it comes to barriers. So talking about the first generation and second generation of barriers, and you see that in a lot of the, you know, cases before as well. When we look at what does it mean to have a full, you know, unabridged right to vote? What is an abridged right to vote? What is an unabridged right to vote? And then looking also at like, you know, majority, minority districts and things like that. And are you looking to, you know, make minority voting power, you know, the strongest it can possibly be? And what is the role of U.S. government there? And so many of those different things. What I think is important in the second passage is that it is more nuanced, and the first one kind of doesn't even touch on.
I think the Ginsburg dissent, it attacks more of the structural problems with all of these voting barriers, where she very clearly attacks this is a problem, this is a problem, this is a problem, whereas the opinion of the court, as delivered by Roberts, is just like, no, it's cool, don't worry about it. Like, look at these numbers, they're fine, which goes from, you know, formal equality.
Right. Right. Yeah.
I was wondering, when trying to point out that the covering formula is what kind of raised the rates in these states, did she at all talk about kind of what's happening in some states where that model has never been used? Like Pennsylvania, for instance, has a very strict voter ID law and hasn't had to submit their plans to Justice Department. So was that addressed at all as kind of an evidence that where these models aren't into effect, like you do see?
I mean, what she did talk about was the fact that there are, there's what's called an opt-out or a bailout, or opting out and opting in. So even the the Roberts decision said, you know, this is ridiculous. You know, these states are in effect being discriminated against on the basis of activities that they undertook in 1965. They've changed. And she pointed out that any state or jurisdiction that wants to argue that it should be exempted from these provisions has the opportunity to go to court and ask for that. Some had been allowed to opt out, and many had not. I mean, that's partly what these 600 cases. I mean, she's saying that yes, there are, and some cases, some jurisdictions had been pulled under these regulations, even though they were not under them initially, because people had brought lawsuits or the Justice Department had gone after them. So it's maybe not exactly answering the question that you're asking, but there had been movement, and she was aware of that, and the court was aware of that. But again, they decided not to.
And in states that are not covered states, you can still bring a lawsuit, or the Department of Justice can still bring a lawsuit. But again, it's after the fact as opposed to the pre-clearance requirement. What else do you see in there?
Any other comments about the differences here? Yeah.
Talks about backsliding in the second one. They really talk about backsliding first. And I think that's something that's really important as well.
Mm-hmm.
Just taking into consideration the fact that when you take away the umbrella, when you get wet.
Mm-hmm. Mm-hmm. What does she mean by second generation barriers?
Oh, there's a.
Yeah.
I think another very hard to accumulated disadvantages.
Okay. Someone else? Yeah.
When you aren't allowed to use voters and tests for the old-fashioned ways of security voters, this would be kind of the evolution of that as a way to take or to disenfranchise minority voters without being penetrated.
Yeah. So just to give you some examples, redistricting in ways that disadvantage minority communities, canceling elections when when the white majority realizes they're going to lose. These are based on some of those 600 pre-clearance cases. Curtailing early voting, shifting to at-large voting so that minority populations get outvoted. Delaying an election, moving a polling place out of a black neighborhood to an inaccessible location, purging voter rolls of black voters, preventing people with a misdemeanor record from voting. So a lot of very creative, sometimes intentional, sometimes not intentional, but on their face don't appear to be about race, but in effect are about race. And that's, I think, a huge difference is that what Ginsburg wants to look at is the effect, going back to the LBJ Johnson quote, look at what's the actual effect of a neutral law. Does it have a discriminatory effect or not? Whereas in the majority, Roberts wants to just take this very narrow, formalistic numbers view. And another thing just to point out on the Ginsburg dissent is her language of voice in a democracy. So she's looking at the end result. She's like, do minority communities have a voice in the democracy? Not, are the numbers exactly equal? And so she has a much more robust idea of what needs to be done, to achieve the goal of the Voting Rights Act.
Okay, so now we're going to switch to.
Can I ask a quick question about the decision by Roberts? Do other parts of it address the states' rights issue more or equally as the now where everything's full with races?
Absolutely, he focuses a lot. I forget the language, but he talks about how these states are being discriminated against.
They're being humiliated. He says that we're humiliated. It's an unfair humiliation.
But does he focus more on that, or the argument that he's presenting?
Really both. I mean, he definitely talks about these numbers as being a key to the decision.
Yeah, but the humiliation of these states is also.
But also like the challenges too of like when they're trying to redistrict, correct? That can take like multiple years of going back and like working plan that might work, might not work. We're gonna try and create a minority, or majority district and add these two, you know what I mean? It's just like, you know, it can be a really long process that can, you know, be laboring, although it's important. It's important as well.
All right, so we're gonna, here's two more, another pair. This is from the Fisher decision, the affirmative action case, the University of Texas. And here, I just, you know, we chose neither one of these is the opinion of the court. The top one is Justice Thomas, who wrote a concurring opinion, agreeing with the opinion of the court, and then another dissent from Justice Ruth Bader Ginsburg. So take another couple minutes, look at these as a pair, and then we'll come back and discuss them.
He would have gone further than the court. He would have struck down affirmative action in that case.
Right. Well, except he realized he couldn't do it in this case. You know, he says, you know, that wasn't before us. You know, I would have struck it down in Grudery's.
Right. And you know, the new affirmative action case, they really won't get the opportunity to do that either, because it's really not about affirmative action. It's about the political process that led to the amendment.
Right. That's good.
It is good, actually. I realized that when I was looking at it more closely. They're not talking.
The language is so unbelievable.
Pander to faddish theories, affirmative action, a fad. And also race mixing, that is really surprising language. Should we tell them to talk amongst themselves?
Oh yeah, we want you to talk about these. Do the same way you did before, so.
Talk amongst yourselves. I mean, I think this is really the same thing, where she focuses more on the lingering effects, the context, the reality, what's the result.
Right.
Whereas this one focuses more just narrowly. Can you believe it? It's a fad, he's calling affirmative action a fad, something that will just come and go and that is popular and everybody jumps on board. I know, it's bizarre.
It's bizarre. It's bizarre for you to say that. Like,
Well, yeah, I mean, the irony is just painful to even think about. Yeah. Probably should make this shorter than the last one. And then this, we're just gonna, I guess we should give them a minute to read it.
And then we'll ask the question, why?
Or I could read it. I could just read it out loud.
Or we could give them a minute to talk among themselves about why this one
the
might have
result
been
was
decided
different.
differently. Numbers are thin, but they're still.
I thought
they
the
seem to be
went on
engaged.
too long. The questions, she never answered any of the questions that were asked. I mean, actually, I thought she was kind of interesting, all the statistics.
She was engaging for a while, but you know, I was walking back up with Audrey Smith. This is very. No, Audrey Smith, the director of admission. The second about the admission. You know, I find it very annoying when people invite you to get in and talk. And don't hear you. I thought that was.
Should we go back? You want to do this one?
Okay. All right, let's reconvene and see what did you see, what struck you about this pair, the language in either of these? Yeah.
Clarence Thomas says the Constitution does not pander to faddish theories about whether race mixing is in the public interest. Yeah.
Right. It's the language is pretty intense here. Yeah.
What struck me was the close intersection of class. So if we were to follow Thomas's opinion and make it so that I guess you could say that the federal institutions are unable to quote unquote level out the playing field, then that only leaves private institutions able to like implement this. And if private institutions are the only ones able to implement this policy, then that raises the cost. And so, but at the same time, if private institutions are able to provide aid, then that depletes the quality of their education because they don't have funds to provide resources.
Interesting.
Yeah, it's a very interesting.
All intertwined.
Yeah. Yeah. Other comments? Yeah.
You were talking about how the Thomas's statement, the all applicant opportunity within the law is kind of very idealistic language, as in if we all lived in a very egalitarian society, that would be the ideal that we would be looking for, but it almost kind of discounts all experience of discrimination or any sort of understanding that it's not an ideal society.
Yeah.
Right. So there's no sort of cultural, political, economic context for what he's writing, which is precisely, this is, Ginsburg does have a way with words, but, she says, only an ostrich could regard the supposedly neutral alternatives as race unconscious. I mean, she's saying Texas's percentage plan was adopted with racially segregated neighborhoods and schools front and center stage. We're dealing with a society that is imbued with racial inequality, and we have to take that into account in our policies. Not to do so is to, yes, I mean, I guess it's a kind of idealized view of American society that.
And of the Constitution, to say that the Constitution does not pander to theory about whether race mixing is in the public interest is baloney of the worst kind. Of course it did. It defended certain interests.
Right. I mean, I think the other thing that's really interesting here is, and this is not just Thomas, this is throughout the majority decision as well. They keep referring to these programs as programs of racial discrimination. So there's a kind of turning of language on its head, which is powerful and problematic, precisely because it's powerful in that way. Yeah.
What he's doing is he's really ignoring the realities of the de facto segregation that we live in now. He's pretending that, sorry, I'm going to try my he's saying that assuming that students who are of color have like authority to go to kids that's not what the laws are doing. It's saying that like kids who come from predominantly from schools that are predominantly minority schools tend to have fewer resources to get into these other schools. It's totally ignoring all the other types of capital that you need in order to get into these institutions. He's saying that just because of color we shouldn't assume that they can't get in, but that's not the reality. The reality is not the economic or social capital necessary. They don't even think it's idealistic, like you guys were saying. He's trying to move towards a society by ignoring the actual problems rather than facing them. It's just extremely ignorant.
Yeah, I think, the other way of saying what actually both of you were saying is that he's implying here, or that these are matters of individual access and individual achievement, whereas Ginsburg is saying there are structural barriers here that are affecting people as a group. And if you don't take that into account, you're missing not just the background, you're missing a very big part of the story of what's going on.
Well, and also the context of using the amendments to the Constitution that were passed after the Civil War to protect the rights of white people. It's sort of an irony.
Okay, I think maybe before we lose everybody, we have one more. And this we didn't give you the dissent. We just the majority opinion. And here, we'd like you to read this and then talk among yourselves for just a couple minutes and think about why or how it was that this decision was different, in a sense. That here, the court decided, the majority of the court decided in a, what we might call a progressive direction, as opposed to the other cases where the majority of the court decided in a somewhat retrogressive direction. And what does this language give you any clues to why that might have been the case?
Who's in the majority on this? I assume it was Sotomayor, Ginsburg, Breyer, Kennedy. And Kagan. Okay. So really the swing vote was Kennedy.
Suspects dissented: Scalia, and Alito, Roberts, and Thomas.
Give the wrap up?
Okay.
I'll say something before you wrap up.
Okay, so then do you want to do this last piece?
I think we should go. All right, can we reconvene? So what do folks think of this passage? Why did the court rule in favor of rights here? Yeah.
So something that our group talked about was a similar idea would be taking this case 30 years from now and saying it's no longer relevant because this isn't, we're in a post-homophobic society. And that's kind of like the parallel to saying we're in a post-racial society. You're like, oh,
oh, this is no longer relevant, and now we're humiliating states, so we should get rid of this.
Okay, someone else, yeah.
I think it's interesting looking at three decisions side by side coming out of the same court, and sort of the inconsistency between the relative levels of progressive ideology at play here. And I think one thing I'm struck by is that the difference in who the plaintiffs are in these cases. And in thinking about Kimberly Crenshaw's analogy about which classes of citizens would be allowed to participate in dominant culture, it's the people who are the most assimilated to the project of the state. And so thinking about Lee Windsor, who is first of all not sexually threatening because she's a widow, and second of all is incredibly wealthy and white. She's suing because she had to pay $300,000 in estate taxes. Like, lucky you. What was the size of that estate? So I think it's interesting to see that the court is so ready to admit same-sex couples because they're presented as non-threatening, and in fact, is assimilating to the project of the state by attempting to appropriate the structure of the nuclear family. I mean, this isn't a challenge to marriage. It isn't a challenge to the way we organize, families in the capitalist enterprise. It's, attempting to expand that project, which benefits the state at the end of the day.
Yeah, great.
But I think that this is not a big jump for the court because it's equality in name only. There's nothing risked by just extending this new benefit of marriage to a class of people who wants to participate in the same structure. Whereas I think people who are advocates of affirmative action and advocates of the Civil Rights Act want to change something about the structure of our government, about how it treats inequality, and this doesn't do that.
Yeah, great point. Yeah.
I think at the same time, the legal rationale behind all three decisions is pretty similar, in that that both this one and the affirmative action, the civil rights,
Voting
case,
rights.
privileges the decisions of the states,
Yeah,
the
yeah,
rights of the
right.
states to decide either their own voting systems or their own marriage
Mhm.
laws.
Yeah.
And all three of them privilege have basically decided the rights of the individual to be treated equally under the law, regardless of extenuating circumstances, which is most important.
Good.
Yeah. Kim.
Going off what Jamie said, just the phrasing they have in the decision, it imposes a disability on the class by refusing to acknowledge the status the state finds to be dignified and proper. It's just like marriage is how you become a dignified and proper member of society, and that in itself is hugely problematic. And then it just kind of solidifies that it goes along with the state's interests more than the interests of individuals. And I have a problem with every decision that talks about children, and it's like, do it for the future. No, do it for right now, and the people who are living right now and dealing with this right now, not for future generations.
Okay. Yeah.
I also noticed, if you look at the language, that there is a consistency in think between all three cases, that it's more of an ideological stance, and it's more about regurgitating values we have that we find to be American, not just in terms of the nuclear family, but also, they don't give specifics, which we saw in other, ruling cases. And instead it's talking more about, it's not addressing it as a structural issue, it's saying that, this is what happened, it's very linear, instead of talking about, why maybe, each individual component of, how, DOMA denies specific, interrelated, rights, being able to inherit your spouse's money after they pass, because that interferes with financial issues.
Yeah. Someone else? Yeah, in the back.
I'm beginning with the assumption that each of these three cases are kind of serve the state's interest. So in the case of the first two cases, part of my understanding or the way that I look at it is that during the Cold War, it was to the state's advantage to look kind of racially egalitarian.
Oh, interesting.
And so we had more policies that, so we had the development of affirmative action, or we had, any number of gains that were made could be just because people fought really hard, or it could also be because it was in the state's interest to look good to third world nations, who we were trying to get them on our side during the Cold War.
Yeah.
And the Soviet Union would say, well, do you really want to be like the United States? Like, look how they treat people who are like you. And so we have the state decides, well, we need to kind of come up with something to give people a little something so that we look good. So I guess I'm wondering, given some of the very recent developments around like the funding of the HRC to do work, kind of combating homophobia and advancing women's rights in some countries that the United States has an interest in intervening in and invading. I'm wondering about this. When I look at this, I think, this could be very similar to during the Civil Rights Movement when the state said, well, yeah, okay, at the moment it would be good for us as the state to pass some of this legislation or to have some of these court cases. So I think as the United States begins to cast itself as like a gay-friendly nation, in the same way that Israel does similar things in trying to rehabilitate its own image.
Right.
What are the uses that the state has for a case like this? And I'm seeing like the HRC's campaign as being part of that, where the United States can say, we're gay-friendly, you're not. We're going to come and fix you. Which is not really about gayness at all. It's mostly about like we need to have a reason to put boots on their soul.
Yeah, I think that's a really interesting point to try to put it in that larger historical context. Well, I think one way you can think about it is both affirmative action and the Voting Rights Act, which required the government to be significantly involved in ensuring the fairness of elections, are both positive rights. If we think about the title of this day, which is From Civil Rights to Social Justice, if you think of rights in just a very negative sense, the government can't interfere with my right to get married. That's a very narrow kind of civil rights idea. But if you think of social justice in a more robust way, you would incorporate things like affirmative action, and you would say the government, that you have positive liberties. It's not just a matter of equal opportunity, but but the government has a responsibility in ensuring that people can actually realize their liberties. And if you look at the Windsor case, it's just a very narrow, formal, negative right, whereas the other two involve positive liberties. And with a conservative court, they would be more comfortable with just that formalistic negative right, but less comfortable with the more robust rights of affirmative action. That's at least one way I read it.
Okay, I think, we thank you for your engagement and your involvement. I would just add a little bit to what Carrie's just said, and sort of drawing on a couple of the comments in this last piece as well, that in addition to, we can look at this in some ways as positive rights versus negative rights, but I think the other kind of frame that we have is to think about structural change versus individual rights. And the Windsor case was framed totally in terms of individual rights, and that whereas the voting rights case and the affirmative action case are about what Ginsburg kept emphasizing. There's a legacy of racism here. There are structural problems. You can't keep that the individual rights language in that context is insufficient to address the structural problems. And I think the other piece here, and part of what we see in the language of the majority opinions in both of those cases, is that when you're engaging structural barriers, you are directly challenging power and structures of power. Whereas the Windsor case, in a sense, is, as Jamie was saying, is sort of asking in. It's not saying, let's get rid of marriage. But both of these are challenging, both of the others are to some extent posing challenges to those people who are in positions of relative power in the society, and given the personalities and the ideological views on the court, it's not surprising that these decisions came down very differently. Anyway, so thank you for your engagement and involvement, and I guess the other thing we wanted to sort of leave us all thinking about are, when we're confronted with these issues, and which are very much still out there in the media, to think about those framings and the reframings and how to use an alternative framing of the sort that Ginsburg used in many of these cases to try to address the claims that, you know, we need color blindness, we need individual rights, we need non-discriminatory processes, et cetera. Whereas Ginsburg is arguing that the only way to take into account of structural barriers is to be race conscious. So some food for thought as we go on with the day. So, thank you very much.
People brought out the points.
Yes, they said what we
I thought
wanted to say.
Eric's point was really interesting. I mean, it's kind of cynical, but